Dear students, we know that the Constitution of India is considered to be the general will of the people of India. It is a document of immense importance. It is not only the basic law of the land, but the living organic document by which the other laws are created as per the requirement of the nation. The life of a nation is dynamic, living and organic. Its political, social and economic conditions are always subject to change. In this changing scenario, a constitution drafted in one era and in a particular context may not be suitable in another era in a different context. It becomes necessary, therefore, to have devices, machinery, or some process by which the constitution may be adopted from time to time as per the contemporary needs of the nation. Such changes may be brought by different ways, including formal method of amendment contained in Article 368 of the Constitution. Article 368 of the Constitution does not prescribe any express limitation upon the Parliament's amending power. Since the commencement of the Constitution, a constitutional battle has been fought in this regard both in the courts as well as inside the Parliament. It appears that Parliament has been asserting its supremacy as enjoyed by the British Parliament, but the Supreme Court has been interpreting Parliament as a creature of the Constitution, exercising powers under and not beyond the Constitution. The Constitution, though, expressly confers amending powers on the Parliament, but it is the Supreme Court which is to finally interpret the scope of such power and to spell out the limitations, if any, on such amending power. This battle between the Parliament and judiciary gave birth to one of the important doctrines in the form of limitation on Parliament's amending power, which is known as the doctrine of basic structure. The basic structure doctrine is a judicial creation whereby certain features of the Constitution of India are beyond the limits of amending powers of Parliament. This doctrine was evolved in the famous case of Kashmananda Bharati versus State of Kerala, popularly known as the Fundamental Rights case, in which the court observed that Article 368 of the Indian Constitution did not enable Parliament to alter the basic structure, or we can also say the basic framework of the Constitution. From then till very recently, this doctrine continues to be the limitation upon the Parliament's power to amend the Constitution, in spite of the fact that Article 368 is really silent as to the width of amending power. There has been a long journey, almost 2 decades, in carving out the doctrine of basic structure, or we can in other words say an implied limitation on amendment powers possessed by the Parliament under Article 368.